Шановні учасники, всім доброго ранку. Ми розпочинаємо за 1 хвилину.
Esteemed participants,
Good morning to everyone. We will start in 1 minute.
Вітаємо вас.
good morning everybody, esteemed participants. This is the second day of our International Scientific Conference, Administrative Justice, Protection of Electoral Rights by Administrative Courts of Ukraine. You know, this webinar is scheduled for 2nd July. You all know that these are the dates when we celebrate the administrative justice. Yesterday we had quite an intensive program. We worked for the whole day. Different areas where our participants took a very active participation. One of the sessions was devoted to elections as the form of the power of the people. Another session was the electoral rights of the citizens. Then today it's the second day of our international conference, and we will talk on peculiarities of consideration of the rights related to electoral process. We expect we'll have fruitful discussion. Please keep in mind we have a lot of participants today, and the declared topics are very relevant. Many things indeed to discuss. I'd like to add that yesterday we didn't find a solution for all issues, both in practice and in theory, so we'll be happy to see you all active and interactive to find solutions. Let me remind you about our rules. You all know how to operate Zoom. I'd like just to remind you that you are kindly requested to stick to the time frames. Thus, we'll have sufficient time for further discussions in addition to the presentations. Also, you're kindly requested that in case if you have any questions, you may use the chat or you can ask your question in writing in the questions section, and then you'll receive the answers in writing, maybe in person, or maybe we will address the answer to the whole audience. So we'll do our best in order to satisfy the needs of everybody and the interests of everybody. So we are starting now. The first presentation. It's devoted to direction of improvement of election code based on lessons learned from 2020. I'm inviting to the floor Denise Kovrichenko, Senior Legal Consultant, International Foundation for Electoral Systems, IFES. The only point that I'd like to make very briefly is that yesterday our participants often mentioned the problems stipulated by the practice of use of election code. Many of them emphasize the need to ensure the stability of the current legislation, and even there was an idea to create a working group led by Mr. Klitschkowski in order to process all the ideas generated through the practice and experience in order to improve the legislation and the election code, thus creating proper conditions to implement the guarantees of electoral rights of the citizens. So please, the floor is yours. Good morning. Certainly, I will not be able to cover all the topics related to enhancement of the whole election legislation. I remember we tried to write some conclusions, and it took like 20 pages volume. I'd like to concentrate on some major issues and the way they are depicted in the current election code. The two key principles of the election right as stipulated by constitutions are the principles of universal and equal electoral right. Well, we had a number of processes to improve the code, and some amendments were made in order to ensure these principles, including the rights of the people with disability, gender-related voters, some other aspects, but still there is a lot of space for improvement, and still the proper implementation of these principles is not ensured yet. I'd like to mention some points like the context of universal electoral right. It's about elections in view of security risks. If you read the codes, you can see that actually there is a lot of space for discretionary decisions by local authorities about whether the elections are possible or not. The decisions are really made by military civil administrations at local level, but this is evidently a violation of the right to vote, because these administrations at their own discretion establish whether the electoral process is possible on their territory, hence generating the risk that some categories of the citizens will be removed from the election process. So here the code needs some serious changes where we need to clearly define the criteria which prevent from conducting the elections. And second, there should be an authority, probably the National Defense and Security Council, which maybe generate some final decisions on whether it's possible or not for certain territory. So the decision about implementing elections in view of security risks should be, this process should certainly needs to be streamlined. Another point is about the security to be made by a candidate in order to be able to run the elections. Of course, on one hand, that may be a clear limitation of an access And if we look at the provisions of the election code as far as this election security is concerned, it's a significant amount, 650 minimal salaries for the president. It's clearly discriminatory provision. Venice Commission stated that a number of times. In addition, there are different ways for further what happens to this collateral security later on. In some processes, the collateral is returned back to the winner only, in some to everybody, depending on the level of elections. If we talk about local elections, it's clearly far away from the real economic conditions, and in addition, discriminatory because better well-off candidates have much better opportunities to take part in the elections. Then the grounds for return of the security collateral. The Venice Commission recommendation was that if a candidate receives a certain percentage of votes, like 3 to 7% or maybe more, then this collateral security needs to be returned anyway to the candidate. Third point, the guaranteed mandates, and here we see the violation of the constitutional principle, because a candidate receiving the guaranteed mandate does not belong to any specific constituency origin, so they do not need any campaigning. They receive the guaranteed mandate, thus clearly have an advantage comparing to other candidates which are prevented from this opportunity. So here we see a violation of the constitutional provisions concerning the equality of the right to vote. In connection with these guaranteed mandates, which and these candidates are not in fact elected, they do not receive any votes of the voters. Then another point about the equal electoral rights, it's the ballot form and the way to vote abroad. The polling stations abroad, their process is organized quite differently from how it is done in the territory of Ukraine. Abroad, the voters can only vote for certain party list, not for a specific candidate. These methods of voting, as we believe, fails to meet in full the constitutional requirements. Talking about the gender quotas, they have already been mentioned here. Rather, the comments were positive because, as local elections showed, the quota of women increased and representation of women increased. But as we could see, sometimes this concept is abused, and in some types of election, the violation of the required quota constituted the grounds to refuse registration, and then the quota was still violated. So here the code needs to define very clearly the consequences of a failure of maintaining the quota, like rejection of the registration, and to make it very clear that actually there are no alternatives to this rule. Talking about the self-proposed candidates, it's not against the Constitution. But actually here we can see that if a candidate cannot propose himself or herself, that to some extent is again violation of the constitutional principle. In many countries, such opportunity is possible. So we suggest that at least at the local level, these self-proposed candidates should be given an opportunity to run elections to make the opportunities better equalized for everybody. And one more point that I'd like to stress within my time framework is about the campaigning. Again, we have a significant cluster that can be enhanced in the legislation. Again, the FATF and Venice Commission stressed that number of times. First of all, it's about the contributions of the candidates and political parties to the election funds or foundation. As of today, there are no limitations on these funds, and the Venice Commission saw a violation of the principle of equality of the candidates and campaigning, because the candidates who are better off have certain better opportunities to campaign. So here is another field that can be improved through limiting the individual contributions to the election funds of candidates. There are a number of other points that certainly will be mentioned in further details by the following speakers, but overall, talking about the election code, this matter of principles and compliance with the principles is very important, because if we fail to implement these principles in full and in compliance with the international practice, the situation certainly needs to be improved and enhanced. And I know that the working group that is drafting the amendments to the election code is aware of that, and they are trying to do something to better regulate the election process. Thank you for your attention. Thank you very much indeed. It's a pleasure to see you among our presenters. I'd like to note that your comments are really at very serious constitutional level. They certainly will be heard and incorporated. We hope you will be able to even engage in this effort together with the working group, because yesterday this information was announced about the establishment of such group led by Mr. Klichkovsky. So we will be happy to welcome you to participate in this working group, or at least we'll be happy to receive any comments in writing from your side. Thank you very much. Colleagues, we will move forward now. The next subject matter is implementation of sources of law by the court of first instance. The speaker is Vasily Ilkov, judge of Administrative Court, professor, doctor of legal science, and he will talk and he will try to outline some solutions of the problems that the courts face when resolving electoral disputes. Because, you know, the time normally is very limited to consider these cases, the judges certainly need to deal with this quite complicated problems, at the same time following the election code procedural requirements, which certainly makes it more complicated to find the proper solution. So I invite to the floor Mr. Vasily Ilkov. Thank you.
Thank you. Good morning, dear colleagues. I would like to congratulate you on Administrative Justice Day's celebration, and that's really a tradition to mark it with annual conference. That's the initiative of Mikhailo Ivanovich, who really became a regular conference that we're having today. The first conference was dedicated to public service, civil service, the second to taxes, third to social disputes, and today we are talking about electoral disputes. And it's remarkable that here at this conference we see among the participants judges, practitioners, academia, scholars, representatives of observers at the elections. So that's a unique opportunity to discuss the most pertinent issues and develop recommendations, and upon implementation of these recommendations, we'll see facilitation of resolution of the electoral disputes, because that's kind of, complex cases. Election cases is exclusive jurisdiction of administrative courts. So that's a kind of a litmus test for us to see how the provisions are implemented, because administrative courts are the only courts that have the constitutional status apart from the constitutional court, naturally. And it is us that the interest to protect the interest of exclusive right of representative democracy are vested. That's the right to representation in public authorities, the suffrage rights, and every 5 or 6 years the courts of the first instance and other courts that handle electoral disputes as courts of the first instance, they face a lot of challenges in handling electoral disputes. They work 24/7 in the special operational regime, and every judge is very well aware of that. So let me just cover some of the issues that are linked to the application of law, sources of law in this group of disputes, and the issues that arise when handling this category of disputes. Last year, administrative trial courts had to apply the electoral code for the first time ever. We are used to handling certain types of disputes. As the judge of the administrative court, let me focus on the issues of application of law that, or other challenges that we faced when dealing with electoral disputes. We are going to talk about the application of the sources of law. Yesterday, we heard some related issues addressed, and it was interesting to get the insight of the colleagues. Starting 2004, we saw the scholars that analyzed this issue, Bezenko and other scholars and practitioners addressed these issues. And Article 2 of the Election Code, we see a very interesting word. In preparation of the elections is governed by the Constitution of Ukraine, this code, the law of Ukraine on the Central Election Commission, the Central Register of Voters, and other laws of Ukraine, and other legal acts. So we see that the priority in the code is determined with reference to special provisions that are provided for directly by the code itself, separate provisions of the law on the CSC, and the law on the Central Register of Voters. There is not a single word mentioned here about the administrative code because disputes are handled under the administrative code. We should have mentioned that we have a special procedural legislation is effective in our country. Because all the laws are mentioned here, the law of the CC and the law on the Central Register of Voters contain provisions of substantive and procedural laws. The Code of Administrative Justice contains the provisions of the procedural legislation. So the code should be referred to in this article as well. There is a mention in here of other laws of Ukraine, but the code is of higher status. Other acts of legislation and other acts of the CSC, that's what is mentioned here. We have some kind of framework, however, it doesn't contain the specificities of the procedure. Procedural specificities are provided for by special other acts. And the reference that the resolutions of the CSC can govern some procedures. That's what we see mentioned here. And when it comes to practical situations, we can go to the resolutions of the CSC to clarify some issues. And for instance, when we talk about the district EC's formations, we see some challenges here because the resolutions of the CSC does not contain any provisions that are necessary to govern that. What shall we do in this case? Naturally, we have to interpret and apply these provisions, and the court does that. And it's important to know that in practice, we have a separate source appearing, and I'll try to shape this idea since in the course of the years, we see the case law being shaped with respect to resolution of some disputes when applying the resolutions of the code and the when applying the code and the resolutions of the CSC. In 2013, we had the resolution of the plenary session, and there it was said that when defining the priority of the norms, and if you compare the code and other laws, so the norm adopted later has a priority over the one that was adopted earlier. But if it is a subjective right of the election process, then the effect of this norm cannot be suspended but remains effective. So the courts were guided with this principle, and it's very important to apply the provisions as to the necessity of this subjective right protection of the parties to the election process. And another important thing is the period of application. Sometimes we saw the instances when applications were made several hours later beyond the deadline. But while that's deemed to be a violation, this application cannot be registered. The largest number of issues that we faced was at the stage of registration of the candidates. Then issues related to establishment of the commissions and results. When it comes to the registration, we could face different challenges here. Every judge faces a variety of different cases in his practice. The simplest one, we have 2 days to consider the claim. Normally, when we get the claim, we need to inform the commission immediately, but it takes some time to find the number of the commission. That's an older issue, and then we need to request the evidence. Very often, the originals are adduced to the materials of the case, and while we can't adduce originals to the materials of the case, when we ask, okay, why didn't you make copies? They said, well, we didn't have any chance to do that. Sometimes it's just the issue of logistics and funding of the commissions, because the commissions should bring copies to the court rather than originals. Another thing, and it might have been mentioned already, so that's the period of consideration for the trial courts. So with the preparatory hearing, or it could be summary procedure. Having studied the register, you can conclude that there are instances of summary procedure, but most of the cases are heard in general proceedings. The preparatory hearing is grounded by the necessity of collecting evidence and handle all motions. It is viable, but sometimes the parties can advantage of that and motion for delays at least for a day. So it would be good if we had a provision for the court to immediately consider the case on the merits, not to waste any time. Again, we work 24/7, and we can hear the case at night. The time is an issue, so it would be good if you could have a summary procedure resorted to at our discretion. And if a preparatory hearing is necessary, then the hearing should be on the merits immediately. The cases could vary, and sometimes it's difficult to quickly assess the evidence provided. Here it is very important to detailize the procedure of summary procedure and focus on the scenes that are important. For instance, if it is the case on removing the candidate from running. So first we receive the motion to withdraw the claim. Then we turned out that nobody did that. Then we figured out that there were 2 candidates with the last name registered. So the court has only 2 days to deal with all these issues. That's why summary procedure, preparatory hearing, expeditious hearing the course of 2 days, collecting evidence, notification of all parties, all that is of primary importance. And it takes time, and the court doesn't want to waste it for minor technical scenes. And naturally, delivering the judgment. Maybe we okay, we could limit the consideration to 2 days, but sometimes it takes a couple of hours to announce the full text of the decision. Sometimes, if the parties do not object, we consider the case in writing, but we need to have a clear-cut provision whereby it would explicitly say that we may not read out the whole text of the decision in full. So, to recap, I can say that there are some provisions that can be improved to make the work of the courts efficient. I tried to point out some of the provisions that are important to note in the course of handling the electoral disputes. Thank you for your attention, and if there are any questions, I'll be happy to answer them. Unfortunately, 15 minutes is not sufficient to cover all the issues and to address the issue in a broader manner, but that's all I had time for. Thank you very much indeed, very pertinent issues, and it's so nice that given all the complex conditions that we are working with, when we try to increase trust to the court through the case law that we are developing, it's very important to identify the challenges that we are facing in our practical work so that everybody is aware of that. Well, it's important that people are aware that sometimes we are limited by the provisions of law, but the court anyways is trying to develop the best solutions through the case law to protect the rights of citizens and make sure that this protection is effective. Thank you. The next subject matter is the case law and resolving disputes regarding compliance with the gender quota during the local elections in 2020. And the first to speak here, actually we have two to speak here. The first to speak is Pavlo Romaniuk, Associate Professor, Department of the Constitutional Law of Ukraine, Yaroslav Mudry, National Law University, National Consultant of the Council of Europe. And the second speaker is Alexandra Gogolub, PhD researcher, Koretsky Institute of State and Law of the National Academy of Sciences of Ukraine, National Consultant of the Council of Europe. I am not going to underscore the importance of these issues. It's for 2 days in a row when we talk about this. The only thing I would like to add is the following. Could you please divide 15-minute time between the two of you? Hopefully you did that because we want to leave some time for the discussion. So the first to speak is Pavlo Romaniuk. No, Alexandra Gogolub. Okay. Then Alexandra Gogolub.
Good morning. I will ask to put our presentation on the screen. I'd like to say that it's a real honor for me to take part in the discussion in the presence of such esteemed audience. We'll talk about the gender quota. I'll start with some statistic information and international standards we've been guided by. So first of all, I'd like to say that our survey, it's a review of the case law on resolution of disputes with regard to gender quota at the local elections, was supported by Council of Europe project in support of the project of inclusive practices. I'd like to say that overall we analyzed 80 cases, out of which we had 139 judgments. They were determinations and rulings and dissenting opinions, etc. Also, please note that out of all these analyzed judgments, 48 were appealed, 7 were satisfied in part, 8 were satisfied in full, and also the court mentioned the shortened written proceedings, and you can see the cases where this proceedings were applied. Out of all these examined cases, only 3 dealt with the disputes in the communities of up to 10,000 voters. Other dealt with the communities of more than 10,000 voters. So you can see that's an interesting point to analyze the application of the law. So talking about the claimants in these cases. Of course, most of them were the political parties. 52 political parties appealed the rejection to register their candidates, and 17 appealed the registration of candidates from other political parties because of their failure to comply with gender requirements, gender quota requirements. 8 cases where the plaintiffs were the individual candidates. In 56 judgments, we found the references to international standards and the judgments of the European Court. A few words about the overall situation taking place in the world and in Ukraine. Overall, we noted a trend towards the increase of representation of women in parliaments and local self-government. In Ukraine, it became possible because of legislative changes and the funding of the political parties. But an effective application of any provision would depend on the judicial decisions with regard to the disputes. Talking about international standards, as you can see, gender quotas are mentioned in many international acts. I'd like to draw your attention to one of the most important, that's the CEDAW Convention, which directly obliges the state to take measures to ensure conditions for women to take part in all political processes equally to the men. One of the goals of sustainable development of UN also deals with the gender equality. Again, with requirement to ensure the right of women to take part in political decision making. I'd like to say the Council of Europe devotes many of their activities to the standards of balanced representation of the males and females. Again, talking about these gender quotas, this is the ground for these 40% threshold, the rule of lightning. That's actually all comes from these European requirements. Also, I'd like to draw your attention to the fact that the strategy of gender equality of the Council of Europe also defines one of their priorities as a balanced representation in political processes. Also, I'd like to mention that the European Convention for Human Rights and overall the case law of European Court indicates that the gender quota is a positive action which must be implemented by the states, and gender quotas are aimed at moving from theoretical equality to the real equality. And certainly after this goal is achieved, actually these requirements may be lifted when the representation is really equal. Now I'd like to pass the floor to my colleague Pavlo for a more detailed review of the case law as such. Thank you, Alexandra. Thanks to organizers of this event. I will continue presenting our survey as far as substantive law is concerned. So when we examined the judgments, we found a number of issues which allow for making some conclusions and recommendations. In particular, first problem is application of the requirement of at least 2 candidates of each gender. The first in the top 5 lists of the electoral lists. And the problem consisted in that in many cases the courts concluded that the failure to comply with the gender quota cannot be the only ground or the ground at all for rejection of the registration if such a list was formed according to the requirements of the election code. But if we look at the Article 219 of the code, we can clearly see the requirements for at least 2 candidates of each gender in the top 5 of any electoral lists of any level. Also, we would agree with the point of the judges who stated that the election legislation does not provide for any right of any party to break this rule. And the requirements for alternative listing of the candidates of different genders must also be complied with. And this requirement for alternative inclusion should not be treated as insignificant violation because it clearly impacts the distribution of the mandates and balanced representation of both genders. So the consequence of the failure to comply with it should be the refusal to register. Article 209 of the code does not regulate the cases when in the ending parts of the electoral list, there are no alternations. For instance, if you have 31 candidates in your list, you understand that the last unit would be 1, so it cannot be divided by 5. So it's difficult to really provide for this alternation between the candidates named number 30 and number 31. So to enforce this proper gender representation, we concluded that these provisions can be enhanced by one of the following options. One of the options is that if there is only one person which actually overcomes the threshold of the number of people that can be divided by 5, then the favor or the advantage should be given to gender which is less represented. Another point about this balanced representation, it was mentioned already here. I think during the previous days it has already been mentioned as a failure to comply with the requirements for gender representation because of technical errors. Actually, in our analysis, we saw that in each third case, the courts treated the technical error as a potential reason for violating the rule of gender representation, although when only 1/3 of all the cases when the courts concluded that the candidates should be registered. So there were different ways to approach this gender quota by the courts. I mean, when they were supposed to give the answer to the question whether such error can be corrected after the candidates were submitted to the Electoral Commission. In particular, there was a case 7520. The trial court stated that during the submittal of the single territorial electoral list, the plaintiff indeed violated the procedure to submit such a list, but these violations were merely formal, and then the plaintiff corrected the technical error and offered the correct lists according to Article 219 of the Election Code. On their side, the plaintiff noted that they submitted to the Electoral Commission the lists printed with some mistakes, which were different from what was approved at the party congress. Another case was where the plaintiff insisted that they submitted to the commission a draft list. And by the way, that's another case, 7920. I think soon will publish this survey, including the case numbers, etc. And you will be able to read it at the site of the Council of Europe representation in Ukraine. So in that case, the court clearly stated that the draft list may exist before it was approved by the party conference, before it was duly sealed and signed by the authorized individuals of the political party, and before these lists were approved to the appropriate electoral commission. But when the list has been submitted to the electoral commission, including all the aforementioned details, it cannot be viewed as a draft list, which can be resubmitted indefinite number of times to the electoral commission until the political party informs the commission that this specific list is the final version. In addition, what I'd like to mention is that in some cases, the courts, in order to establish any technical mistakes or to assess any electoral lists, examined such materials as the minutes of the party conference or excerpts from these conclusions. In particular, the case 4420, the trial court, when checking the admission, the correctness of the decision, checked the lists that were examined by the territorial Electoral Commission, and the court stated that the violation of the requirement for gender quota cannot constitute grounds for refusal to register the candidates. In this judgment, the court clearly mentions that the materials were submitted to the Electoral Commission, and during the trial, could these materials be subject to further examination? Also, I'd like to draw attention to Article 230 of the Code. There are two paragraphs that should be interlinked. First paragraph is about mistakes and inaccuracies found in the documents which do not prevent from the proper understanding of the document. Second paragraph is about lack of information in the submitted documents, and paragraph 3 is about the identified shortcomings. So in the first case, my interpretation is that if there are any inaccuracies which do not prevent from proper understanding of the document, then they can just be corrected. While the key point is the paragraph 2, if the information is missing in the submitted documents, then only this information can be specified or added. but maybe some will disagree with me with this respect. So our conclusion was that in view of the fact that, yes, Paul, excuse me, you need to really finish. So, as Article 210 of the Election Code mentions, clearly the information that must be depicted. But when we are talking about the electoral lists, where this information is required to be submitted and pulled on, and discrepancies, already mistakes, cannot be deemed as an error. Another case was about withdrawal of the application on refusal to run the election on behalf of the party. The number of such cases is not significant, and I need to say that any applications from the candidate of this kind, whether they agree to run or they stop their participation or they withdraw their participation, would certainly impact the final distribution of gender quotas. So we believe we made conclusion that we certainly need some additional public hearing. They are actually being conducted now by the Group for Improvement or Enhancement of Election Legislation. They already suggested some mechanisms for replacement of candidates in the party lists or electoral lists, and the individual should be replaced by a candidate of the same gender. The other negative phenomena is application of the resolution of the Central Electoral Commission as of 2015, where they stated the declarative nature of provisions on gender representation in the law on elections of Ukraine. Unfortunately, in 4 cases, the courts continued using this resolution, but we need to say that the explanation of that law in that case cannot be applied because the respective provisions were clearly specified by the Election Code of Ukraine. Plus, this resolution of the Central Electoral Commission was cancelled only in 2020. The courts still mentioned it in their reasoning, which certainly is not correct. Some other problems that we saw consisted in uncertainty or different use and application of different provisions of the law, Articles 219 and 230. In some cases, the courts stated that the procedure of proposing candidates does not have any exhaustive list of procedures to hold party liable for violation of the gender quota, and there is a dispute around the notion of gender quota. In particular, some courts treated the requirement of gender quota and alternation of candidates of different genders in the list as 2 different phenomena. Although it can be clearly seen that actually this notion as treated in the law of Ukrainian political parties and the law of Ukrainian elections as the same provisions because of the required percentage of gender representation. So here
You have to conclude, please. And the last scene, that's the last slide. We have to mention here that the most problematic cases were the ones where gender quota was improperly applied. In one of the cases, the court decided, since the data of the register in Vilkiv community make 10,244, so that's a kind of a rough number. That's why they can they can use gender quota not under proportionate system, but rather majority system in multiple city constituencies. And another case, the court incorrectly determined the number of voters in community, establishing that it is less than 10,000, but the CSC confirmed that it was over 10,000, and again, gender requirement was applied under their own system, and given the results of the research, the reasons for different application of the provision are the two: lack of stability of election legislation, since amendments are made just prior to the election, and even in the course of the election campaign, the legislation is changed, and the complexity of election systems and sufficient time to study the system by different parties of the election process, and they are interlinked. Thank you very much for your attention, and apologies for exceeding the time. Thank you, Pavlo. Hopefully, your studies, your research is going to be taken into consideration in the working group. Maybe you'll be willing to participate in the working group. It would be good because the contributions of scholars and experts are valued highly, especially if it is experts that are aware and conduct research of the international standards. Olga Kutsuruba is going to talk about the unity of judicial practice in some categories of administrative cases at the local elections of 2020. I know that women are very accurate, and I'm sure you're going to stick to the time frame, and I'm sure you'll stick to the time that is assigned to you. Thank you very much in advance. Over to you. Thank you. Thank you for the invitation. As introductory words, let me mention observers. Mr. Elkiv referred to observers, and I represent the organization that observes over the elections, and observation at the elections is indispensable from the analysis of judicial practice. So we do not just observe the work of the election commissions, but we analyze all court decisions, whether that's in the course of campaign, during the elections, and after the elections. So all this assessment is accessible through our reports. We are going to publish the report on local elections 1 year later, though, but well, it was just due to the amount of materials, and we wanted to make it user-friendly, and it required a lot of analytical efforts to compile all these materials in a convenient format. So the report will be sent to you, that's for sure. Assessment of court decisions is an important element, not only to assess the actions of specific entities of election process. For instance, we analyze whether territorial commission violated the law. While doing that, we do that on the basis of the court decisions, but it's also important to take into account court decisions to assess the elections, generally speaking, even when you make a conclusion where the elections took place and in what manner, whether it was free and democratic. Today we're talking about local elections, but previous elections and the experience then proves that the full stop in the election process and its assessment is made by the court, though that's the worst case scenario of the elections that you can imagine. When analyzing the case law and judicial practice, we note some trends. They were referred to yesterday, but let me share our observations. What is really remarkable to note when analyzing case law? The first thing is diversity of practice and different positions of courts in the disputes where this same substantive law provision is applied. Basically, so different positions of courts in identical situations. We discussed these decisions with Paulo in gender-related cases. When we see absolutely opposing decisions made, we see reference to be made by the court to the European court case law, and in one instance the courts recognize that failure to comply with gender quota allegedly is excessive formalism, and they refer to the Joff versus France judgments. Other courts in identical cases refer to Zhevnik versus Slovenia judgment of the European Court that deals directly with the application of gender quotas and participation of women in the elections. And from our perspective, that's the decision that, or the judgment that should be applied and serve as a roadmap for national courts. Speaking about difference between excessive formalism and where there are real grounds to refuse a candidate in registration or refuse, or rather when there are violations when commissions are established. Let me quote some examples. For instance, the package of documents was submitted, and one of the documents, and that's a resume that was handwritten, the signature of the person is lacking. So registration and other documents do have this signature, but this one has the signature missing, and the court believes that signature is an inevitable element of the document, so that proves that the document is inaccurately done, and the person was refused the registration. That's one example, that's one decision to try to resolve the dilemma where there is excessive formalism or violation of compliance with registration requirements. On the other hand, we have a manifesto, a program of the party. They failed to comply with the number of characters in it, and the court states that, well, the fact that the program exists is important, and failure to comply with some requirements as to some elements of the documents, though the latter directly mentioned by law, cannot serve as the ground to refuse the registration. And the second large issue is the following: whether the final court decision guarantees de facto reinstatement of the subject in its rights. And there are several angles here. The plenary resolution dated 2013 states that it's a discretionary powers of the Commission and mandating the Commission to act respectively is the wrong way to go. It should be given to the discretion of the respective election commission to decide in the case. But we have instances when courts indeed complied with this right concept on the one hand, but on the other hand, it led to the fact that the rights of the entities were not guaranteed because the commissions either couldn't make this decision because it was beyond the established period of time, or they refused to deliberate on this issue, refused to put this issue on the agenda. On the other hand, in 50% of the cases, we see the courts mandating the Commission to undertake some actions, and at least here, the CSC had a say, and very often it made sure that this decision was executed, and there is a mechanism to bring to account for it. So it would be good if legislation would clearly state at least some examples when this type of obligation would be appropriate. So that's the issue to discuss, but we need to play with it. The entities that have the right to apply. So, well, the logic of the election process is first we have entities and then the election commissions are set up. But it's different when it comes to local elections. First, we have territorial election commissions and territorial election constituencies established. That's outside the election process, and only after that we have a registration of candidates. And there is a huge issue: what shall we do when the requirements of law are not complied with respect to territorial organization? And the only option here is to contest this decision by the voter. The case law is diverse. In many instances, courts believe that there is no direct violation of respective right of the voter in this instance, and sometimes the decision is made that violation of territorial organization matters. For instance, in 5 constituencies that was the case, but the elections were registered or documented only in 1 of them. So this violation remains without a judicial oversight. The courts refuse to consider that given pro forma ground and claim that voters lack equal representation in specific constituency. And if you look at the OEC reports at different elections and IFES reports, you'll see that this wording, namely that voter can apply only in the cases when his or her voting rights are violated. That's something that is not in line with the international standards. And here, at least to some extent, when we have some stages of election process that are outside the election process itself, we need to provide the right to contest and the right to judicial oversight too. The period of appealing, that's another important scene. We know that there are some specific groups of cases that are not linked to the election process. They are considered as part of the general proceedings, Denis referred to the elections in 18 communities in Donetsk and Lugansk Oblast. At the moment, we 1 year after the elections, we see the decision of the CSC revoked by the Court of Appeal. That was the decision as to impossibility of holding elections in these communities. And it is directly linked to the rights of voters, and it is directly linked to the election process. And here we need to go by legislative amendments, or at least by clarifications, because this group of cases should be heard immediately when it is pertinent, rather than 18 months after actually the elections were held. A few other examples. I'm not sure whether I have time for that. You have 2 minutes. 2 minutes. The cases when we have identical cases, but different decisions are made by courts, usually that's when we talk about registration. That's one group of cases. And the second group of cases is the voters list. So very often we have really diverse opposing decisions made. The voter requests to be included into the voters list, and the last day for this request is Thursday. However, the person is on the voters list, but at the other polling station. Usually that's typical of IDPs, and the person is registered on the occupied territory. And we have diverse decisions of the court in the same local court. On the one hand, the court claimed that the procedure of the change of the voter and address should be applied here, and respectively the person did not change the address, so that's why the person should be refused. And there are opposing decisions, and as observers and the organization that protects the rights of voters believes that this decision is much more positive. They apply the constitutional norm, and they say that the person did not request change of address, but this shouldn't serve as the ground to deprive the person of the voting right. While the same goes when the person cannot vote at the other polling station because the person is IDP, and the territory where the person is registered, local elections are not held. So the same happened with the registration of persons at the foreign polling stations, and while the person shows their ticket after the elections, if the person doesn't vote abroad, the person won't be able to vote at all, and the person should be granted this right. The same about including members of the district election commissions into the voting list, and if the person is a member of one election commission and it's not the polling station where the person is to vote, then the person cannot vote. Well, the person is deprived of this right, because logistically the person won't be able to do that. So in one instance, the courts applied formal approach. In the other, they said, okay, so lawmaker did not think through the procedure and did not detailize the procedure in the law, but it doesn't mean that the person should be deprived of the constitutional right to vote. So I encourage Mikhailo, and we underscore this in our reports. We encourage the Supreme Court to pay attention to this issue, given the uniformity of judicial practice, and through clarifications would provide a kind of roadmap in this large group of cases as to voters lists and as to the registration of the candidates. And we hope that this conference is meant to clarify all these issues, and not only to amend the legislation, but also to make sure that we have uniformity of the case law, despite the fact that apart from the CC, Supreme Court doesn't consider the cases with respect to local elections. Thank you.
Well, indeed, it's a very painful problem that we're trying to solve. You know, we've already had several election processes, and, you know, they are evaluated by our international partners. And in this connection, I'd like to emphasize that you are right. The purpose of this event is to identify the shortcomings in the legislation and in the practice, and that's actually what our colleagues are doing. They state that many things depend on practical applications of the legal acts, because unless we apply, we cannot really see the effect, whether we comply with the goal, with the purpose of the legislator in each specific case. Well, our Secretary, Elena Kalashnikova, presented your developments. I'm pleased to say that, because we actually are making just the first steps. Yeah, we are really overloaded, but still we are trying to do something about it, to follow some trends that can be used further on by the courts of the first instances in a consistent way. And here, the Supreme Court judgments are very important because they become the source of law. So here we have a collection of publications which partially have been presented here, in a collection of legal positions of the Supreme Court with regard to protection of the electoral rights. I know they will be placed at the official site of the Supreme Court, and anyone, no matter who, what you are, can use it. And Olga, please disseminate this information, invite the people to consult this website, because we are doing very important work. We are protecting the electoral rights of the Ukrainian citizens. So as our Secretary of our Chamber says, let's move forward slowly. Let me inform you that, unfortunately, because of unknown reasons, Mr. Oleg Marcelak, head of the sub-department of legal sciences at the Shevchenko University, whose presentation was planned about the principle of voluntary participation in the elections and absenteeism. Unfortunately, by some reasons, he could not make it. Maybe we will be able to get in touch with him to find out about whether he will have an opportunity to speak here. So I suggest to our participants that we move forward to the next esteemed participant, who often speaks at our events. He is very good at emphasizing those doctrinal things that are implemented by the Supreme Court in the case law. So, Mr. Vladimir Wenger, Executive Director of the Center for Research of the Rule of Law and its Implementation in Ukraine, PhD in Law, will talk about combating the abuse of administrative resources in elections, challenges and prospects. This actually is a continuation of our yesterday's discussion when we discussed the matters related the issues related to legal certainty, hidden campaigning, hidden propaganda. I mean, many matters that are typical for today's situation, including the considerations of cyberspaces, cyber threats, cyber security. And I think all our courts are very interested in these topics. Thank you, Yaroslava. First of all, I'd like to thank all of you for this opportunity to be here and to speak for you, to share some of our developments related to how we can counter the administrative resource. In fact, the subject matter of my presentation will be somehow doctrinal. I think it will have value as far as the vision, global vision of these matters is concerned. Although there will be some points related to the very substance of a resolution of such disputes for various categories of cases. These developments have been made with support of the projects of Council of Europe, and their projects soon, I think, they will publish all these materials for several European countries, and it will certainly have a wider scope than my presentation. But let me mention a practical point here. First and basic thing is that, unfortunately, in Ukraine, the administrative resource at election is perceived through the prism of very banal, very simplified categories. It may be either campaigning by a public official, making use of the state property, etc. Certainly that's a problem. But I'd like to draw attention to a slightly different and higher level of the systemic administrative resource, which, unfortunately, in developing countries is not just used, just often becomes the foundation of the influence over the elections and their results. What I'm talking about, if we look at the definition of the administrative resource, according to the report of Venice Commission as of 2017 and respective guidance by the same commission, so the administrative resource would mean not only human, material, and natural resources that can be used during the elections by the candidates to actually exercise control over the electoral process or the vote count. This also should include, according to the aforementioned Venice Commission opinions, any attempts and mechanisms of use of public significance of PEPs and any resources that may have indirect impact over the course of electoral process in a country. country. So here I have some doctrinal thoughts, maybe controversial sometimes. I think we'll have time to discuss it. With regard to abuse of legislative resource and how this can impact the electoral process. I will go a bit in advance. First, I jump over some statements. I need to say that for activities of the judiciary, it's a very important point to realize the full scale of this abuse, in particular for Supreme Court, for Cassation Administrative Court as part of the Supreme Court Grand Chamber. I need to say that this global perception of these points, for instance, in the determination of Grand Chamber with regard to the polls conducted by the president during the local elections really generates some doubts. I think the reaction could be different and maybe would cover deeper understanding of administrative resource at the legislative level. I'd like to concentrate on four main blocks of abuse of legislation during the election. First, it's frequent changes of the legislation. Indeed, yesterday it was mentioned, and here in Ukraine, unfortunately, the electoral legislation is subject to continuous changes, and we have never had any election campaign without any previous, at least cosmetic or even substantial amendments to the law. I will not talk about the latest event to avoid any political allegations. So in 2017, for instance, as the amendments were introduced 6 times as far as local election as of 2019 are concerned, these amendments were made right on the eve of the electoral process and clearly had an impact over preparedness and readiness of the political parties and their candidates to run the elections. I don't want to remind you about the international standards about unchangeability of the legislation. Actually, at least the requirement not to change anything at least 1 year before the election. And this is not about just the legislation. It's about other essential conditions of organization and implementation of elections. If you look at the Ukrainian practice, I will talk about that later in detail. I mean, territorial organization of the elections, actually, and talking about administrative reform and organization of the elections of the past year creates doubts in whether the participants of the electoral process realize or are aware of the violations, like, for instance, the equality at the elections. For instance, the parties represented in the parliament clearly have advantages as far as their preparation and participation in election is concerned, including preparation of changes to the law. They are the first to become aware of new law or even draft law. So this mechanism and understanding of frequent changes to the legislation should be taken into consideration by the courts when they hear the cases like that. For instance, the questions of the paying pledges when local organizations could not actually pay the electoral pledge at the local level, and the high-level organizations had to pay it, but for that purpose they needed to change their registration. So here this aspect of equality, of unequal conditions between different parties and their local organizations. I just mentioned only one example, and there are many others. Certainly, the situation have very negative impact. Another important block is the influence over the quality of the legislation, and this is a very practical thing. First, it's about mistakes in the legislation, and second, it's about timeliness of decision making. Well, unfortunately, there are situations where mistakes are made in the legislation, which actually implies some consequences for the electoral process. I don't want to give you many examples. I could mention some inaccuracies or mistakes in the legislation then require additional secondary legislation. For instance, decisions to be made by the local electoral commissions, which should not decide on such matters. Like, for instance, in last year draft legislation, many mistakes of this kind were found, and that was about excessive delegation of decision-making powers to the local level commissions. Unfortunately, that may lead to some decisions which are almost or just beyond the legislator's competence or the executive power competence, like if you remember respective resolutions of the Central Electoral Commission, which had serious impact over the implementation of the right to be elected because of their decision to differentiate between different levels of the local council. So talking about the practical understanding of this aspect by judges, understanding the lawfulness of this aspect of the powers of the Central Electoral Commission would certainly help in making proper decisions to protect the rights of a specific participant of elections. Talking about timeliness of decision making, I already mentioned that, but I'd like to stress the points related to administrative territorial reform. The parliament, when passing decisions on changing the boundaries of the districts and regions, in fact, created a very serious problem for local party organizations for purposes of local elections, because they were being prepared for a certain form of election, but then they had to change all of their preparation, which certainly might imply certain violation of the right to take part in the electoral process. For instance, submission of the list of the Electoral Commission, and the Central Electoral Commission last year faced this problem. The issue was who is supposed to submit the electoral lists to the Electoral Commissions, and this actually is quite an important aspect that needs to be taken into consideration. I would also mention here the decision to conduct the elections actually Even this decision by the parliament had some impact over the efficiency of the elections. They actually decided to conduct the session once and then for the second time. And the second block is the omissions by the legislator.
I am not going to detailize that, but the main focus here is the following. In many instances, the Parliament is not entitled to decide on specific issues. Article 90 of the Constitution is a roadmap that tells the Parliament to make laws, and if the Parliament fails to make laws on this or the other issue, can this way or another contribute to the abuses. One example to illustrate that, we discussed this with many participants, including Olga Kutsuruba. What prevented a lawmaker to govern the use of so-called hidden advertising? So to detailize the use of advertising, to detailize the use of social media messengers, Telegram, WhatsApp, Viber, or others that are widely used in our country as means of communication. Why didn't lawmaker govern these issues? Because, well, if the court gets the case where the dispute is linked to these issues, then the courts have to decide on this, and that's usually on many advertising issues, including social media. And it's not that the Parliament couldn't do this. The Parliament could do that because there was a draft law 3884 amended the legislation when it comes to the use of tools 18 to 23, 24, and other articles that cover that open data sources use machine readable tools. All that was covered, but they didn't do the ones that I mentioned. So inaction of the Parliament in this case result in the case that the courts should be governed by the their own voice of reason to fill in the gaps. It cannot be done on a systemic and daily basis, but well, you know, it should be governed by the law. Lack of regulation by law is a very telling example, because many political parties that are represented in the Parliament made use of these tools, social media, for instance, and other things. So they conscientiously didn't do anything about that to adopt a respective legislation that has a serious impact on elections. And the last element, that's abuse of lobbying party interests. Adjusting the election system just before the elections, threshold in the election system 10,000 or more, the composition of the election commissions that allows for some entities to come into agreements with parties, etc. So control over the printing of the ballots by membership in some election commissions of the political parties, and the size of the deposit, a very nice indicator. Everybody who follows legislative amendments remember when at the initial stage we had the draft law in July, the deposit was supposed to be really huge, and as a result of the discussions, the sum was decreased. So all these four categories of issues are in need of additional analysis, understanding, conceptual understanding, and they should be considered when drafting respective legislation. I referred to the decisions of the Grand Chamber, and we need to consider that there is case law and the draft law 4043 on amendments to the law on the CC and surveys. So this legislation could have its say on the case law as well. We can draw parallels with other judicial processes. Recent decision of the Grand Chamber on interim elections in Constituency 87 and others. To recap, let me say that unfortunately in developing countries where we belong to, administrative resource is not limited to just tangible resources such as abuse of positions, money, etc. The scale of administrative resource is much larger, is much more systemic, and ignoring this element, whether that's a doctrinal or a legislative level, or in practical terms, is impossible. We need to consider that when handling specific case, when reasoning the decision, and all that is not only possible, but it should be mandatory. I know that the issues raised are controversial, and I'll be happy to participate in the discussions and answer the questions. Well, it was really provoking, and I'm sure that everybody wants to say something in response to what you outlined. On my part, I'll be honest, my colleagues and I keep hearing the arguments expressed by the lawmakers that allegedly when handling the disputes, we read something in the wrong way, we didn't interpret it properly. It's very important that you said that the courts cannot replace lawmakers. That's a very important thing. We have a division of power into 3 branches, and the courts can do more than they should. We are limited by the substance of the complaints, and well, we are trying to explain this to people, but one other important element that you said, a lot depends on the position of the society. Hopefully we'll see Mr. Marcelak today, who was supposed to cover these issues, that's the issue of absenteeism. But on the other hand, we should see the demand on the part of the society for this or the other issue to be governed and settled. We can set the tone, we can refer to the rule of law, to the constitution, if it is possible. However, we might face huge issues if it is the courts that should decide legislative issues, because we are not courts and our hands are tied. Thank you very much indeed. As a follow-up to the previous topics, we have another presentation of Bogdan Mokhonchuk, senior lecturer at the Department of the Constitutional Law of Ukraine, Yaroslav Mudry National Law University, PhD in law, is going to speak about election campaigning. Cannot conceal identification, who will talk more about hidden advertising. 15 minutes is yours. Thank you, Miroslava. Dear colleagues, dear participants of the conference, my name is Bogdan Mokhonchuk. You heard my title of the presentation, so that's indeed going to be a follow-up of Volodymyr's presentation. Can I share my screen, or can you do that? Next slide. Today we are going to talk about hidden campaigning. That's a new phenomenon in Ukraine. That's the structure of my presentation. First, I'll talk about the fundamentals of campaigning, analysis of hidden campaigning, and the conclusions that I made. Next slide. The new feature of the election code is introducing or rather banning hidden campaigning. But issues with identifying this type of campaigning are linked to the fundamentals of campaigning in Ukraine. Why is it important to talk about that? European Court in its judgments stresses that election campaigning is linked to freedom of expression. It's one of its forms, and it should be secured because it's impossible to talk about free expression of will without it. On the other hand, providing for subjective voting rights could be a limitation to the freedom of voting rights. So, because it is acquiring the forms of campaigning. It's important because in administrative jurisdiction, the proceedings linked to campaigning, that's a separate group of cases. You see the numbers in the classification register. On the other hand, these cases are linked to general jurisdiction court practice, so that's administrative and criminal cases sometimes, because administrative code and the criminal code of Ukraine, Article 160 that deals with bribing voters contains corpus delicti, and these provisions, according to the Supreme Court decision of 2018, are blanket type of provisions. So if you talk about bribing that is linked to election campaigning, to identify that, we need to establish the fact of campaigning, and we need to go to election legislation to do that. So both in cases of the offenses and administrative offenses, campaigning plays its role. The advantage of the election code is the following. The campaigning was unified, Section 8(1), but the signs of campaigning, purpose and subject remain the same, and the method of governance stay the same. That's kind of general permissive nature. The purpose of campaigning, we all often talk about the references to the candidate in the party's logos, but the purpose of campaigning is encouraged to vote or not to vote for the candidate or the party, and that's a broader category and more judgmental. And legislation keeps the features of incentivizing to be left at the discretion of the claimant, and the courts therefore are governed by really broad understanding, because it is the court that is to establish whether there is an incentivizing element here or not. General permissive nature for governance means that the legislation of Ukraine election code establishes or allows campaigning in any forms, in any means that are not banned by the constitutional laws of Ukraine. For the courts, it means that if we try to say that some actions are unlawful, we have to clearly find reference in the election law or other laws, restrictions as to campaigning, identify the specific restriction, and then this action can be deemed unlawful. So in the issues of campaigning, we have wider discretion and a lot of judgmental categories. One of the new scenes of the election code that experts insisted on is the ban of hidden or indirect campaigning. but the signs of indirect or hidden campaigning are missing in the acts. The only thing lawmaker did is establish that hidden election campaigning is forbidden. At the same time, didn't provide any features of hidden campaigning. On the contrary, the legislator complicated this situation because the ban was established in one sentence with the ban on disseminating materials that are not marked as per the election code. And there is also the wide list of features that allow to identify election campaigning. And that's kind of similar to political advertising. So political advertising was removed. It is covered by the law on advertising. That's a broad category that could be typical not only of the political process, but these are some features, not exhaustive list of features that allow to identify campaigning, so they are covered in one sentence, and that leads to the following. National Council on TV and Radio Broadcasting website has this article whereby the council wrongfully lists the scenes that can be taken as hidden campaigning as identified by lawmakers. So everything is confused, and the National Council says that hidden campaigning includes publications, slogans, mottos, etc. But given the fact that hidden campaigning is banned a priori, so if it is identified as hidden, that it means that that's dissemination and it is unlawful. So this broad list of features allows to say that all or any type of campaigning is banned, which is not quite right from my perspective. The resolution referred to by Volodymyr that dealt with a survey initiated by the President and the Grand Chamber of the Supreme Court. Supreme Court judges identified some features of hidden campaigning, and in the survey the Supreme Court did not establish any features of hidden campaigning, but established the set of features, and it was inter alia the permission of an entity to directly or indirectly associate a certain event or activity with the dissemination of materials and link it to specific party, so incentivizing the voters. And again, you know, the manner it is done, that can be misleading. There were dissenting opinions. Olena Kubenko, Judge Gudima had their dissenting opinions, and Judge Gudima believes that video materials, or rather the surveys, the word in Ukraine that's you, allowed to associate a specific party with these video materials that could be a sign of hidden campaigning. Hidden election campaigning was recently banned by the law on national referendum, and we are discussing the draft law on local referendum, and the draft law on local referendum contains some features of hidden campaigning with respect to the issues that can be offered at random. So similarly to other positions, it should be associated with specific person, should be encouragement to vote, but in using that is offered here, funding of this hidden type of campaigning cannot be done from the party election fund.
Я, власне, перейду вже, так буду наближатись трошки до висновків, щоб не...
Well, I'm approaching my conclusions. So the hidden campaigning, which is prohibited indeed, should be considered through two components. It's actually campaigning and concealing. Actually, campaigning is not an urging to vote. Probably a more complicated point is about this concealing. If we look at the dictionary, concealing means masking, camouflating something, covering something with something else. As for me, concealing means choosing such a way to do something which would complicate the identification of a campaigning activity, meaning when they choose intentionally the method which would prevent from identifying campaigning as it is described in the legislation for that purpose. Of course, many different means can be used, audiovisual, etc. What kind of means can they be? As for me, for instance, that may be distorting of names, logos, symbols. So if we take a candidate or a party and their slogans, we distort them in such a way that you cannot state directly that this is this specific party, or vice versa. You take the name of a party or a candidate or slogans or logos, and we try to identify them or to present them as universal human values. Or equalize them to, say, some holiday greetings or names of famous books. So when we mask a name of a party or a candidate or another ways to incentivize with the means that actually prevent from identifying them as merely campaigning. To identify these means, what we suggest is to analyze this hidden campaigning through the materials and forms of campaigning, some materials that are disseminated, and we could associate these materials with the hidden campaigning. Also, it should be checked through the logos and symbols of a party. I mean, the answer to the question whether we can clearly identify who we are invited to vote for. Or I would mention some experience of campaigning during other elections, because in the last 2 years we had 3 global election processes in addition to territorial community elections. Also, this suggestion in the draft law is that the hidden or concealed campaigning cannot be funded from the electoral fund. I found a similar provision in Latvia, where the law on electoral campaigning identifies only one sign of hidden campaigning, which is funding beyond the electoral established funds. So any campaigning of this kind will be deemed unlawful. But when we talk about concealed campaigning, when it's funded from the electoral fund, should not be a separate provision of the law. It will not be hidden because it's funded from the lawful funds. In fact, Indeed, the legislature gave a big margin of appreciation and discretion to the courts, but the courts needs to deliver well-grounded judgments. The legislator certainly could help by describing more specific signs of prohibited activities. But we still can see some case law in formation. In fact, there is nothing bad in limiting, putting restrictions on some forms of campaigning. I remember an example of 1974 when the Italian singer Gignola Cinquetti lost to ABBA group and put the second, had the second place, but her song called Yes was prohibited for broadcasting in Italy, and the reasons for that were that they were conducting the national referendum to legalize the divorce institution. And actually, it was stated that this Yes, Yes song can be viewed as a form of campaigning. So you can see the imposed restrictions just to ensure equality of the rights and the right to exercise these equal rights. So in order to make sure that all opportunities are equal and the will and the voters have equal rights to express their will, this concealed campaigning can be identified in the following manner. First, the purpose: to urge to vote or not to vote. Urging vote or not to vote. Since it's concealed, it should be characterized through a special way of doing it, which makes more complicated to identify it as the campaigning. And third, in order to identify an activity as concealed campaigning, it should be compared with other campaigning materials, candidates' biographies, party logos, symbols, I mean the materials which allow for identifying specific parties of candidates or candidates, and also through analysis of experience of campaigning which is lawfully used by a party or an individual during the elections. We understand that during parliamentary elections we'll talk about the parties, and it's quite often the parties can abuse this concealed campaigning through different types of association. Thank you for your attention, colleagues, and if you have any questions, I will be happy to answer them or to have their respective discussions. But I understand how difficult it is to make decision judgment for the courts without proper legislative support. But anyway, they are doing a good job. Well, thank you. It's very important for us to have a support of different nature. I've been following your presentation. I think these topics will be extremely relevant in the nearest years because Ukraine is characterized with a very democratic nature, many political parties, and these pictures change very quickly. So it's very important and relevant topic indeed. Thank you, colleagues. And I can see many closed windows. We just have... okay, I can see your pictures, your cameras, so I've been waiting for this opportunity to start a discussion. We have time for discussion, actually. That's why we're all here. I suggest that now, before we conclude presentations, another topic which will be presented by Natalia Probe, Assistant Department of Administrative Financial Law, Faculty of Law from National University, member of Advisory Board of the Supreme Court, PhD in law. She will talk about challenges in determining the jurisdiction of the Administrative Court concerning public law disputes related to the election process. Yesterday, Mr. Knyazev set a good tone to start this discussion. He described activities of Grand Chamber of the Supreme Court about how they identify criteria for outlining jurisdictions. And Natalia will now continue this subject matter. Thank you. We are waiting. Well, I'll tell you that to be the last speaker is quite difficult. First of all, because many of the issues that I would like to discuss have already been mentioned. But I'd like to say that there are many experts and just talented people who recognize problems, and which means these problems indeed exist in reality. They are not just fabricated by the academic community. So it's time to look for solutions. Yesterday we talked a lot about the confidence in the elections, the confidence to trust the judiciary, and probably we thought that if any elections are considered by courts, that already probably generates some concerns in the public. Then indeed the courts are now trying to overcome all those biased attitudes, but we still need to keep that in mind. Also, Mr. Smokovich and Mr. Vladimir stressed the lack of stability of the electoral legislation in Ukraine. Well, that's an acute well, that certainly seems to be a problem, but still the legislation probably should not be indeed very static, preventing from any reactions to the changes in reality. For instance, Ukrainian legislation is not prepared for switching to the e-voting, and probably we should be prepared for this huge wave of discussions on whether the e-voting is possible and admissible at all. That's something we should expect. Also, I'm very happy with the fact that the Supreme Court is the authority that states the problem, that crystallizes the problems and urges the academia to take part in their solution. I'm really supportive to this. I read their opinions, I read their website, social media. I like how open the Supreme Court is, in particular through Instagram and Telegram. Indeed, that certainly enhances confidence of the citizens and trust of the citizens to the Supreme Court, which sets a very good example for other courts. So indeed, all of these problems about jurisdiction of electoral disputes are due to these peculiarities of the election process that have been underlined a number of times by the Supreme Court. I will try to be very short. So the Supreme Court stresses in the views some peculiarities of the electoral process where we can find these statements in number of the judgments, in particular some features of the electoral process which have impact over the jurisdiction. In particular, this is a temporal nature, meaning that the electoral process is limited in time. So the courts need to operate within very specified time framework, which certainly increases their caseload. And at the same time, they must defend the rights of the citizens. Another peculiarity of elections, in particular, its impact over the jurisdiction is about establishing the legal status of the Central Electoral Commission. We'll talk about that later. And second, it's about periodic and quite often changes in the electoral legislation. So when we talk about restrictions of the electoral process with some time frame, its temporal aspect. Of course, the Supreme Court is right when stating that during the electoral process, the deadlines for applying with the courts are very short. This legal position often is mentioned in judgments of both Supreme and other courts, and I think it is well grounded, and it's quite often it actually imposes the need to operate very quickly. But these restrictions, time restrictions, imposes very specific obligations on the legislature and executive branch, in particular with regard to clarity of the provisions. Of course, the legal provisions are limited with the principle of rule of law, which provides for 3 different branches of power. But if the conflict arises because of lack of proper legislation, the court would not be able to find a solution, because here the legislator's interference is required. Also, I certainly like that the Supreme Court clearly indicates these gaps where the court is limited not only with the time frame but also with the lack of proper legislation. Actually, the peculiarities related to jurisdiction of the disputes are due to peculiarities of the legal status of the Central Electoral Commission. By tradition, we view it as participants of electoral process, but they have a dual legal status, and the experts view it as also a barrier of some powers, and actually of the powers to solve the electoral disputes. And here we need to understand that any disputes arising beyond the electoral process do not pertain to electoral disputes in the meaning of the Administrative Code. Hence, the jurisdiction of such a dispute should be defined on the general terms. So maybe it would be subject to common courts. We agree with that. Central Electoral Commission has wide competences, not only with regard to preparation and conducting elections, but also with regard to solving some disputes. So I think here the jurisdiction should be identified in a common manner.
Specificities that are caused by dynamics of legislation. Can we apply legal positions of the Supreme Court inter alia and positions of others that were shaped on the basis of the case law during the previous elections? Again, there are several nuances of the case law, and legal position of the Supreme Court is as following. The reference to the High Administrative Court of Ukraine in the cases related to the election process of the previous years is ungrounded. I agree, and I believe that it is a correct position. We keep talking about changeable legislation, and the case law of the Supreme Court is a special element that allows to resolve jurisdictional conflicts and legal disputes, but that's of a secondary kind of nature. It cannot be the main one to resolve various legal issues. That's a very good position, because different disputes crop up at the time when they are governed by different laws, and so the position of the Supreme Court reflects the dynamics of legislation. Next slide. Here is key aspects of the specificities of the election process, the limitations of the election process by time limit, special status of the CSC, and changeable legislation proves that the Supreme Court in its positions reflects all this, reflects the specificities of the election process and stress these specificities. And all this is meant to protect the rights of the parties to the election process. Thank you very much for your attention. That's it on my part. Just key moments that I wanted to stress. Thank you very much, Natalia. We are about to conclude, dear participants of our event, dear the President, dear the Secretary of the Chamber. We don't have a lot of time left, but if there are any questions, we'll be happy to answer them. We don't have any questions in the chat. Maybe that's for better. Maybe the participants received exhaustive answers to the questions they had. But let me underscore some of the moments, and as a moderator, I can sort of set a tone for the discussion. Let me raise the following questions for the discussion, but in your comments, please stay brief. You have only 1 minute because we have many participants here. Pavlo Romaniuk, Alexandra Golub, are you here? Yes. The question, talking about gender quota, if the registration of the candidate was revoked, then the regional lists are suggested to be filled in with the representative of the same gender. But the law local elections, Article 6 of the election code says that every candidate should be included into any regional list. Nomination of the candidates after the registration is not provided for. Where do we get the candidate of the same gender to fill in the vacancies to comply with the gender balance? Thank you. Thank you, Miroslava. In our research, we said that this issue should be further discussed. We have two parties. The first side of the story, that's to provide for gender balanced representation, and the issue of withdrawal or recusals. When we say that the party recalls the candidate, then at least the proposal of the working group on gender issues that developed amendments was the following: not to search for a new candidate, but follow the list of candidates by gender criterion. So you just go down the list already available, but you follow gender balanced criterion. So you don't have to search for new candidates, but you basically replace the vacancy with the candidate of the same gender who is on the list. Olga, would you like to add?
Власне, тут хочу сказати, що фактично тут виступав Денис Ковриженко, і в рамках робочої групи
Денис Ковриженко expressed his proposal, and we have already developed the wording for the provision. So what we move is just we are talking about moving the candidates up along the list, both at the regional list and the national list. But this moving up is possible if you talk about revoking registration of the candidate prior to the voting day. If you talk about canceling it after the day of voting, then we need to take into account the specificity of the election system. If it is a territorial list, then the candidates are replaced depending on the number of votes received. So we can do that by gender criterion only if the candidate was elected by the general list, then we can move the candidates up. So there are many nuances there, but the proposal is there, and if you have any comments or corrections to be made, feel free to send them to the commission, to the working group rather. These amendments tried to remedy the deficiency that was identified when analyzing the case law, when the courts interpret, for instance, the list as the one that has inappropriate number of candidates, or the list doesn't have the leading candidate, or the list does not provide for nomination of the candidates in specific constituencies. It was interpreted as courts as violation and as a deficiency or inaccuracy. And there is a proposal of the working group to clearly define it as the ones that cannot be categorized as deficiencies or inaccuracies and shouldn't lead to refusing in registration. Thank you. Thank you. Any other questions? Let me add. We need to take a broader look, and it's not only about the case law, but about the attitude of the parties to nominating male and female candidates. Unfortunately, they pursue really a very formal approach, sort of, tick the box and that's it. But at a later stage, they can exert the pressure so that female candidates could recall and remove their candidacy. So we need to explain this to the parties by saying that the requirement of gender balanced list is really lawful, and the goal is really the noble one. So it's very nice that we talk about protection of the rights of women at this conference. We still have some time left before I give the floor to the president to wrap up the conference. A question to Volodymyr Wenger. Are you here? No, I'm here. Great. Quick changes of electoral legislation. Naturally, that's a negative phenomenon. But could it be deemed an abuse? And who committed this abuse then? Thank you for your question. You need to draw a line here. I quoted the presidential elections of 2014 and 6 changes that were made then were quite objective, and you cannot talk about any abuses there. And we are talking about the use of police and security service to protect polling stations. The same, goes for transporting the documents. Sometimes changes, even if they are frequent, they are quite objectively substantiated. We are talking about that as abuses when they are meant to provide advantages, lawful or unlawful, given the discretion of the parliament in terms of governing specific issues. I quoted some examples, I can't repeat them, but actually what we talk about here is really clear-cut abuses and frequent changes or late changes. They do have an impact on the participants of the election process. For instance, parties that participated in the changes of the election code were engaged in the sum of the deposit. But those parties that are not represented in the parliament didn't know anything about that. And they learned about the sum of the deposit just a very short time before the campaign was launched. And it does have a serious impact on the candidates because they have to know where to get money and, what kind of money we are talking about. So I am not saying that frequent changes by default is an abuse, but it often happens so, and we have just to consider that and be mindful of that. Thank you, Volodymyr. Any other participants that would like to add something? Olena Kalashnikova. Just a follow-up later. Marina Rusu wanted to add something.
Я хотела спросить, задать вопрос относительно того, если оказывается давление.
If the pressure is exerted on the party candidates for them to withdraw their candidacy. The internet connection is awful, so we can't hear.
У нас есть такой случай, когда такое имело место. Когда действительно об этом было сделано и показание на него незаконного давления.
Пані Марино, я перепрошую, дуже поганий зв'язок, вас не чути знову.
Very bad connection. We couldn't hear you. That's the second day in a row that we have these issues. You can write us on the chat if that's convenient for you. Apologies. We just can't hear you, but you can write in the chat. Thank you. Apologies, dear colleagues.
Технічні модератори підказують, що помітили підняття рук від пані Коцюруби, так? Правильно?
Madam Kotsiruba raised her hand. The answer to the question that was asked before, we can talk about practice and legislative regulation here. Article 157, paragraph 1 of the Criminal Code, if the criminal case was instituted with respect to the pressure exerted on the candidates, so that's clearly an offense. And when we have training of the police, we do stress this, and any attempts of exerting pressure on the candidate by political party fall under article, I quoted, of the criminal code. But speaking about the practice, when it comes to the reports about that, we didn't have any made to law enforcement agencies, and the local elections that's actually related to gender quota. We don't have respective decisions on charging under Article 157. Our organizations conducted polling of female candidates, and indeed there were instances when candidates stated that they were made some offers, or the offers were made to female candidates in other political parties, but usually these are latent type of offenses. Normally female candidates do not report this to law enforcement agencies, and indeed we need to explain this not only to the national police but also to the female candidates, so that in case of the pressure, they should go to law enforcement agencies. And then we have to consider what would serve as the evidence, because usually these are one-on-one meetings that this type of suggestions are made, and it's very difficult to find respective admissible evidence in this regard. Thank you, Olga. Very interesting. We also noticed that Mr. Romanyuk wanted to add something. I agree with Kotsiruba. That's exactly what I wanted to say. Okay. Raised hand of Ilkov.
Дякую вам. Якщо дозволите, от в мене був невеличка думка щодо попередніх тем обговорення. Я хотів би сказати, що
with respect to previous issues raised, gender quotas,
саме практика, де було тлумачення щодо безпосередньо певних помилок, так? Скажімо, в нашому суді так склалося.
We are talking about interpretation of deficiencies in our court. We had cases where we did confirm that the candidates were removed from running, but the issue was different. It was a political party that was removed from running, and while we heard this case, the party didn't have any chance to change their party lists. So just for technical reasons, the party couldn't participate in the elections further. So we need to look at the district administrative court's case law in this regard to case law is in the process of making, and at the local elections the case law was shaped by the courts of appeal as well. And when it comes to the application of law, the case law can serve as the source of law. Thank you. We've heard your position. Dear colleagues, dear participants, let me read out what Marina Russo wrote. That was the question she wanted to raise. Did you have any instances when the candidate on the party list was subjected to pressure with the purpose to make him refuse to be included in the party list? Did you bring to account the persons who did that? Do you have any experience in this regard?
Русу. О, пан Романюк.
So I can see Mr. Romanyuk wants to answer this question. Which language should I use? Russian or Ukrainian? Well, this event is in Ukrainian. I hope Marina will understand because it's a national level event. We'll then translate your reply into Russian in the chat. So, actually, I've already tried to answer this question. Have we had such cases? Theoretically, maybe yes, but we've never received any reports addressed to police based on Article 157 of the Criminal Code. The current criminal legislation certainly contains this potential description of this potential violation as a pressure over the candidates, but so far there have been no cases when anybody has been prosecuted for that. Second point is to answer Vasil's comment concerning discrepancies between the deadlines for electoral process and judicial procedures. Indeed, if we remember 2019 when they printed the ballots in the last day, and actually the head of Electoral Commission then stated that because of changes in the electoral lists, the electoral process might fail at all. It was about local elections where the legislation provides for only 50 days to complete the whole process. And actually the experts discussed this option to extend these deadlines to 60 or 70 days. I think this is one of the ways to find a solution. Thank you very much. Also, we saw a hand from Mr. Mahanchuk. Do you want to ask a question? Yes, very briefly. Talking about criminal proceedings, I'd like to draw your attention to the fact that in July 2020, the criminal code was amended, and now it became more difficult to prove the fact of electoral violation because they are not now within the crimes where the covered investigative actions can be conducted. And also I agree with Pavlo's word about the deadlines. I would even try to reconcile it with the Code of Administrative Justice. What Pavlo described, it was 2019, that was party new movement of Mr. Saakashvili. They had just, they didn't have any choice but to just include them into the list, which certainly was certain violation of the law. So these deadlines for appealing decisions of the Electoral Commission should be put somehow in correspondence with the duration of respective judicial proceedings. Otherwise, we really jeopardize the efficiency of the electoral process. Thank you, colleagues, and I cannot see any further questions or comments. I have a question for Vasily Ilkov. Article 141 of the Ukrainian Constitution grants the right to vote to inhabitants of some specific communities. That's the question related to decentralization. Have you ever had proceedings related to non-compliance with Article 141 of the Electoral Code? In fact, I have never faced these problems of application of these provisions at our district court. Maybe there were some cases of this kind. It would be also important to discuss the jurisdiction of such proceedings, because the jurisdiction might not be related to electoral dispute in this case. That may be a different category of case. But the question about including into electoral lists, that's the competence of trial courts, common courts, not administrative courts. As far as my court is concerned, no, we have not seen any significant number of such claims, so that we can, so that they could be, let's say, combined into a collective claim. So probably this category of actions have never actually led to significant violation of the electoral rights. Thank you, thank you. Also, we have a secretary of our Chamberlain Kalashnikova. She has a question. Please, could you ask your question? Well, when Natalia spoke, I'd like to concentrate our attention to her reservation about that the court cannot make decisions on case law of, I mean, what was your question? Yeah, you were talking about references to case law of Supreme Courts or other courts. Well, it's hard to answer this question very shortly. I was meaning the restriction of quoting, unquoting judgments of other courts, because we have these problems. Our lawyers are always give advantages to the practice, to the case law, and their reaction is very painful when the Supreme Court takes a liberty to change this case law. And it's quite often that the lawyers like referring to case law of Supreme Courts, but or they may refer to case law of other trial courts when this case law had been generated before changes of the legislation. But if it's still the current legislation, this case certainly can be referred. But if the legislation had changed, and this is what happens with the electoral legislation all the time, I think these references to case law should not play the prevailing role in deciding the case. Well, thank you very much for this position. Indeed, that's the right statement. But I'd like also to emphasize that when we talk about application of a legislative provision as basis to resolve a dispute. Our code of procedure clearly states that only there should be a legal provision or legislative position already expressed by the Supreme Court. No other legal position can be used in order to substantiate a judgment. But also I'd like to draw attention to Article 242, Part 5, but also they have Part 4, by which judgment should meet the requirements of administrative justice as defined by this code. It should be fair, unbiased, timely, etc. I think this provision would allow for using the previous case law, provided that the conditions that you've just mentioned are met. But this is just for discussion purposes. Well, thank you, colleagues. Thank you. Do you have any further comments or questions with respect to the matters that we are discussing, talking about the protection of the electoral rights of our citizens? Please raise your hands. If you, Olga, have you raised your hand by mistake? No, I did just to continue the discussion that Elena started, and what we always insist upon is that unfortunately at local elections where the last instance is the Court of Appeal, I think this is the main problem of the local elections, and we discussed that yesterday. So to continue, I would just like to say that this case law of the Supreme Court is not in place yet to generate trends of such elections. So in order to obtain the legal position of Supreme Court in any case related to local elections, the participants had to write an application to the Central Electoral Commission. Their complaint was not satisfied, but the only purpose was to make sure that further on this complaint will be considered by the Supreme Court. What can we say about this approach? Isn't it kind of an abuse, maybe, when a subject is trying to transfer a dispute to Supreme Court? Unfortunately, yesterday I couldn't participate, but I think Oleg mentioned that yesterday because that's a challenge for a Central Electoral Commission, because in most of the cases they dismiss such a complaint because they do not have proper powers. But that actually creates a situation where the Central Electoral Commission has to undergo judicial proceedings almost all the time, almost continuously. Well, thank you for this comment. Bogdan Makhanchuk, you raise your hand, right? Yes. No, thank you for the floor. I would just like to add very briefly to what Natalia and Elena mentioned. I'd like to say that indeed the judicial activity often is an interpretation. Certainly it should not counter the legislation or constitution, but when we talk about the understanding of the legislation, it's up to the judge. The judge can base his or her interpretation on a doctrine or whatever. If you will remember, that is the provision says of 2017, the judge is supposed to protect the rights in any way that he or she deems necessary. Talking about the changes to Code of Administrative Justice. They changed the numbering of the articles, but there were not many changes in the substantive part of this code. Well, now the election code integrated a very significant number of previous provisions of the election legislation. So I would rather concentrate not on the names or numbers of the articles, but on the substance of what they present. Yes, thank you very much. It's an interesting topic. We often discuss it with the colleagues. Talking about doctrinal approach, maybe referrals to some academic researches, international standards, case law of European Court. All these resources are very important, and indeed we have much bigger resources now, talking about the access to the European case law or academic resources, but unfortunately our human resources are limited. Our time resources are limited to really become aware of all that. And since we're talking about electoral rights and we are a chamber dealing with the elections, so sometimes we even work on weekends to make sure that electoral rights are properly protected. Still, we are trying hard. Believe me, we are trying hard to find the best decision to each specific case so that we enjoy confidence of the public and they really look for fairness through our court. Well, dear participants, unfortunately, we need to wrap up. I am sure we'll have many other meetings. I can see Mr. Lars Broker, who joined us, and that's a real pleasure to have you here. Yeah, we had representative of Moldova yesterday, and as of today, we also have here many national experts. I'm pleased to see here representatives of NGO who finally can see that they really may play an important role in these processes of enhancement of the respective changes. So we are trying hard to really develop our case law so that final results of our efforts are depicted in our legislation. Sometimes we can see just very small. Yes, our moderator said Mr. Lars Broker would like to add something. Please, the floor is yours.
Yes, thank you very much, Mrs. Bilak. I only wanted to add one more thing, and just 1 minute, so I won't take too much time, but it was very interesting for me today to see the point of view of so many young scientists and their point of view through the jurisdiction of the Administrative Court. It's very interesting, and that's a very, very important link, this link between scientists and the practical jurisdiction. So I congratulate you to this and to this conference. It's the 4th conference. I took part in the first one. It was about public service, one of my specialities, and but also the topic of this conference was very, very important, even in a European context, the law of elections. So I would like to thank you very much for inviting me to this conference. It was a great pleasure for me, and also a great honor to take part. And I hope in the near future we can meet again face to face in Ukraine or here in Germany. And a last comment I have to do, you might understand this, on football. All the very best to you. There are not many teams that struggled so hard like the Ukrainian team did. So it's your turn to beat England. So do it better than the German team did. So it's your part now. And it's, so you struggled very hard. Try it again. So thank you very much.
Дуже дякуємо, пане брокере. Ну і
Thank you very much, Mr. Broker. And for me, it's a big honor to give the floor to sum up a two-day work of our fourth international conference to our president, leader with capital L, leader of administrative justice, Mr. Smakovich. Mikhail Smakovich, over to you. Good afternoon, ladies and gentlemen. A few words about the last session moderated by Miroslava Bilak. Let me repeat what Mr. Broker said. It's a real pleasure for me to see this young group of scientists, of human rights defenders, the defenders of electoral voting rights in Ukraine. They are really very well versed and they have really very good and deep understanding of the issues. And our generation shouldn't have any fears. We know for sure that the rights of voters will be protected by them in our country. It was very nice to listen to you. Indeed, we do have the issues. Olga Kotsarova outlined them, especially with the cases that are on the border lines of the election processes. Specificities of handling electoral disputes are limited time-wise. We have 2 days, 5 days, 2 days to appeal. The appeal should be submitted directly to the court that made the decision. So that's the 24/7 type of work, the work on weekends, and we, for instance, if the decision was made on Friday, then on Saturday, Sunday, the court is not working, then you won't have time to appeal it. So these are kind of nuances that we all need to take into consideration. So while we are talking about the specificities, well, anything that is happening not during the elections is something that is kind of easier to deal with, just because of the time. It was nice to listen to Pavlo Romaniuk, Alexandra Holub, Volodymyr Wenger. Thanks for sharing your vision as to legislative amendments needed and the issues raised by Natalia Khliborov with respect to new changed practice. Let me say what I think about it. New or changed practice, that's the case law with respect to application of the same norm. There is a norm, there is a legal position of the court that applied that. Sometime later, it was reviewed by the judges and provided its updated vision of that. That's the change of practice. If the norm was changed, then that's not a new case law. That's the case law on the application of the changed norm. That's the case law as to the application of updated or new legislation. So that's my vision of it. And it seems to me that it is the right one. I really liked the presentation of Bogdan Mokhonchuk, a resident of the city of Lviv, about hidden advertising, campaigning. We do have a lot of issues there, pending issues. And when we talk about the abuses, then we shouldn't hesitate and say that the parliament is abusing of the right because they amend legislation just before the elections or in the course of the elections. And when you were talking about voters list, and party list, I remember that talking about party list, it's Zdrozhenia party, and one of the persons who was on the party list was suggested removing his name from the list, and he was invited to the CSC, and the court mandated the CSC to enter or re-enter his name into the list. The CSC refused to do that because it was late at night and somewhere in our country due to time difference. So the elections have started and some polling stations were open. He was number 161. And well, it wasn't so much about the number on the party list, but about the abuse of the right. Well, sometimes the person is on the party list or on the list. Well, it was his turn to become member of the parliament, but just before that, the legislation was amended and his name was excluded. It was with respect of Mr. Bogdan, the former head of the office of the president. So there was abuse of the right, as we stated. Well, thank you very much for all the issues that you covered. I was really impressed, and it's really nice to have this type of scholars in Ukraine. I know that some of you have been working on these issues for a while, but apart from Olga Kotsuruba and Denise, I haven't met you. I'm really impressed. Thank you. As to the conference and the sessions that we had at this conference, so the judges of the Cassation Court, the representatives of the Secretariat did their best to have this conference organized and held at the highest possible level. I'm sure that the conference was a success. Well, as Mr. Broker said, well, he was in the country when he could, but he has always been with us at our conferences, at least online, and we do appreciate this. We organize the conferences not so much for the judges, but that's for the scholars, for human rights activists, for the persons, entities that need protection in public relations, in administrative courts. We do all this for the Ukrainian people. And all the sessions that we had were really interesting. I didn't manage to attend all sessions entirely. Session 2 was missed a little bit by me. And I'm going to listen to the recordings, and it's going to be the presentation of Lars Broker and Hinterasa too, because I missed them. But we do have the recording, and I'll be able to listen to that. I had some other commitments and couldn't make it at this very time. To sum up or to conclude the conference, I would recommend to the participants of this conference to stay in touch with us, because we'll keep developing the issues discussed at this conference. We didn't have time to cover everything, to have everybody express their comments. So we'll keep organizing conferences, roundtables, and you'll be invited to participate in them. We would be interested in your input. For the time being, we are going to come up with the recommendations, and here is the recommendation. We would suggest recommending to the organizational committee to produce the collection of the European Court judgments. We did that before. These were the judgments that dealt with the access to public information. It was like 10 or 15 European Court judgments. It could be just a small size of the booklet. And as soon as the judge or human rights activist have this type of booklet, it would be really handy to use it in their respective work. That was Tretьяков, Kushnir, Ivodyanikov, their presentations that sort of recommended this. I would agree, and I would suggest producing this kind of a booklet. The president of the Cassation Court and the head of the organizational committee could come up with co-authoring monography. So we can come up with the requirements for this monograph, and then the authors could contribute their thesis, their publications. So that would be a monograph that we would publish based on the presentations that we had at the conference. There were a lot of other recommendations expressed, namely to amend legislation. So the president of the Cassation Court, of the Administrative Court, is recommended to set up the working group to develop amendments to the Electoral Code and other legislative acts that would consider all the recommendations and comments made at this conference. I understand that there are working groups, and some of you are members of this working group, but I think this working group that I have in mind would complement the work of other working groups, and I think that would contribute to the importance of the recommendations that would be developed at these working groups. And several participants agreed to be members of this working group. So if you want to become a member of this working group, let us know, please. We'll be happy to cooperate with you in the future. So that's a brief list of recommendations based on the results of our work. We thank our partners for the support on organizing the conference, Council of Europe project, supporting transparency, inclusivity, and integrity of elections in Ukraine. The project support of constitutional reform and support provided to the parliament in reforms. The coordinator of the OSCE projects in Ukraine, German Fund of International Legal Cooperation, and special thanks to the foundation because that's the foundation that we started these conferences, and thanks to their major contributions, administrative justice is developing, as well as IFAS. Thank you very much, and this goes to the National Ostroga Academy, National Shevchenko University, thanks for the cooperation, and National Academy of Legal Sciences of Ukraine. Special thanks go to the head of the Council of Europe office in Ukraine, Stin Nerlov, director of German Foundation for International Legal Cooperation, Dr. Stefan Hulshorster, and international speakers, head of the European Association of Administrative Courts, the president of the Vienna Administrative Court, Edith Sala, head of the highest administrative court, Lithuania, Ginteras Prėževičius, the president of the Constitutional Chamber and the highest administrative court, Rain Larsen Broker, the head of the district court, the Marina Russo, the president of the Constitutional Court of Georgia, retired judge, the representative of the Venice Commission, Professor, Doctor of Law, Georgi Papuashvili, the president of the NGO Ukraine 2050, the president of the World Congress of Ukrainians, and Chuli, national advisor, legal issues coordinator of the OC projects in Ukraine, Alexander Vodyanik, law of the European Court of Human Rights, Dmitro Tretyakov, senior consultant of the International of IFAS, Denis Kovrizhin, manager of the Council of Europe project, support to better access to justice, Irina Kushnir. We do appreciate your input. We do appreciate the participation of all reporters. We are grateful to scholars, experts, representatives of the Administrative Court, the Supreme Court, everybody who participated on organizing and preparing this conference. We are grateful to Arena. Special thanks go to the interpreters. We have simultaneous interpretation, as you see, and the interpreters into the sign language. We are grateful to young scholars for their involvement. National School of Judges of Ukraine. Special thanks go to our moderators that professionally did their job, as well as the representatives of the Secretariat of the Cassation Administrative Court. Thanks to all and each of you. And please remember, since you were here, this conference will keep cooperating with you in the future. We'll keep developing the issues, conclusions made at this conference. So we'll have 3 formats to work further after the conference. Please stay healthy. And we believe that Ukrainians will prosper in their native homeland, and will contribute to that by our fair decisions, judgments, and exemplary conduct. See you soon. Thank you. I declare the conference closed.